Hello, everyone. I've got here Lenny and Conrad from Flatiron Law Group, who have been sponsors to Legal Innovators California since its inception. Actually, thank you very much for supporting us over the years, Lenny and Conrad. I'm delighted to have them at the conference for yet another year. This year is a little bit different, though, gentlemen, because you are bringing a new, exciting products to our audience, and I know that you have also been doing some very in the influential work with Stanford University as well over the past few years. So I would like to pass the opportunity to you guys to introduce yourself to our listeners and viewers and tell us a little bit more about Flatiron and of course the other two initiatives that you're bringing to California next month.
That's great. So, Conrad, you want to go or I'll start?
All right, where you go?
Okay. So I'll just give a quick overview. So we're Flatiron Law Group. We're a boutique firm that handles mergers and acquisitions, tech transfer, and tech development, and even early stage companies. But what we do that's different is that we do our work on a flat fee basis, which rings rings loud in the minds of all clients. The innovative way we do that involves technology and a different labor model that I'll let Conrad do in more depth. But beyond just Flatiron Law Group, we work with Stanford Law School and their computer science department to develop AI products. We're advisors to Stanford and work with Dr. Megan Ma, who's speaking at this event. And that wound up last year producing a product that was released at a Codex event. The Codex is the Department of Law and Informatics at Stanford Law School. And we've taken that product, which is a negotiation training platform for young lawyers and law students on negotiating components of a mergers and acquisitions, which is our practice area. After a year and a half of work with her on the initial product, we've now commercialized that product, and it will be shown at our booth. We also have another product, Deal Driver, which is a complex transaction management platform, also based upon the teachings and learnings that we've gotten from Stanford, that is infused with AI as well. And we can talk a little bit more of those as we go forward. Conrad, why don't you, why don't you get a little more background about Flatiron?
Yeah, Timo, I mean, we've spoken about this before. We created Flatiron with a mission to disrupt the law firm business model. So we know to get away from the billable hour, to get away from the marking up of junior labor, and to go to more of a business rational thematic. And we've gravitated towards a fixed fee, a success fee model, and we've been at it now for several years. And the principal components of the model are, as Lenny pointed out, the leverage of technology, both our homegrown technology and third-party technology. The way we deploy labor, we do it principally on a general contractor basis. We don't sit a lot of labor on our balance sheet, and of course, by being efficient and by being running principally a SaaS-based practice in terms of the platform that we use. Those technologies and the platform, the deal platform that we incubated over several years to help us to be more efficient, that internal utility, I call it, became so important and attractive to the client community, then now we've actually, as Lenny pointed out, we've spun that out into a separate commercial company. We call that Deal Driver, and we've infused it with AI, and it's a platform that we've developed now over several years, and it's at a fairly mature stage. So that's part of the offering that we bring to the table.
So talking about the flat fee pricing structure that you guys are um, very successfully introducing to the market, this is still very much of an uncomfortable topic for many law firms. We do a lot of conferences around the world and North America specifically. And whenever we have tried to introduce a billable hour panel discussion to our agendas, we have always struggled to get willing law firm participants to actually take part in that discussion. It will be very interesting to me, and I'm sure to our listeners, to understand what the client experience has been with the flat fee offering that you guys have been putting forward, and especially in a field like M&A, which tend to be quite complex, but also very expensive for customers.
Well, Timo, we like to say, we are former BigLaw partners, and we banged our heads against the walls of BigLaw for decades trying to bring innovation. But as Lenny points out, it's like turning around a steamship, or it's kind of turning an ocean liner in terms of the culture and the economic model at BigLaw. We like to say we got outside the the firewall. That's just like any other industry. You drive radical innovation by getting into a startup where we could control the economics, we could control the model, and that's the freedom we got by forming Flatiron. I mean, there's some challenges. Obviously, we're a startup company. We have to put capital at risk, and but we had the freedom to experiment with the model. Now, Lenny, you want to talk about the client experience. I mean, from a fixed fee perspective, what we're bringing is predictability. It's a predictability and a consistency to the fee expectation, and that's what's attractive. We've coupled that with maintaining the same, or I think sometimes even higher levels of quality because of the way we leverage technology. And we've also introduced, because of our technologies and because we're not driven by labor, and we're driven by efficiency, we've actually introduced efficiencies for the client, and the way data is managed, the way data is parsed, the way we extract intelligence from data, all those things that we do internally to make ourselves more efficient, make the client more efficient. Lenny, you want to speak to that?
Yeah, so I'll amplify that a little bit. So in the first instance, we have this model that doesn't rely on a bench of people that we have to employ on a weekly or monthly basis. We bring a team together, similar to the phrase we use as a contractor model. We bring teams in, people that we know, people that were trained at the major firms and spent their time there, and then they become available to us for a variety of reasons. Maybe it's that they decided to get off the heavy burdens of hours, or maybe it's because they've gone, they like the remote and aspect of it and so on. But that's where we start, where we have that pool of personnel. And then we leverage technology significantly, more so than even the bigger law firms can, because we wrote it ourselves. We built systems to run the deals, and we price ourselves at a varying level based upon the complexity of the deal, what we anticipate the needs will be for that transaction, usually based upon the size of the deal, the governance factors with regard to internally, is going to be voting, no voting, the number of locations involved, if it's a multi-location, whether there's labor issues, is it just a technology company, and so on. And we look at all these factors, and we also know what the larger firms are charging since we've been there for many, many years. And then we come up with a price that fairly represents the burden, but it's not based upon hours. It's based upon what is the value to the client, and we negotiate that. And it's usually, at the high side, a third, sometimes half what the adversary is charging, sometimes even lower than that. And the benefit to the client has been, as Conrad mentioned, is confidence that knowing that that's the number. Now, there are changes. If a deal, for example, pivots and goes in a different direction, it's not what's in the letter of intent, because that's what happens sometimes. Well, then fine, there's a readjustment, and every client just about, it's like, yes, this is not what you planned. It's not what we planned. We'll make an adjustment to the fee. But we can take those chances and those risks even if the client says no. We're happy. It's the idea is to provide that confidence and predictability in the fee. And in every deal, the clients have been so pleased that when they finished the deal, they came back and say, that tool that you have, are you ever going to commercialize it? And the tool that we built is actually supported by our former clients that said, you know what, we couldn't have done the deal without that. So that's what led to our commercialization of what was an internal tool that leveraged technology and the practice together to make it easier on the client, the sell side or the buy side, and even the adversary.
Is the tool having the possibility to be a fully self-service utility, or does it still require to an extent the Flatiron Group support from a law firm perspective?
That's a great question. And no, it does not require Flatiron for its implementation. The product will go through beta this summer. We have alpha people on it now. It'll go beta next in June, and then it'll be released later on in the summer into the fall. It does not require our input. It does require, the same attention that any other legal tech product does. So you make decisions with regard to how to implement it in terms of, how you're structuring your data and so on and so forth. Easy implementation, but thereafter, you'll find that you do things in a different way because you have so much more data early on. But it doesn't necessarily require Flatiron to run. So other law firms have asked us when they saw us as an adversary using our earlier versions of the product. They said, "Can we license this?" And that led to the commercialization of it. And each of those firms was up and running, the same day that I turned on the older versions. Now it's a commercial version. It'll run independent of us running on our own platform.
And then from that, I understand that the main buyers and users are M&A practices within law firms.
Yes and no. M&A practices within law firms, M&A operations within corporations. So enterprises are quick to appreciate the value because it reduces, if we're not involved, if they were to deploy the product, it reduces the burn that's happening with their outside law firms. But it's also not just M&A. It's a complex transaction management system. So we focus on M&A because that's our practice, but we had requests from others. And so it has the ability to handle any complex transaction. It might be commercial leasing. It could be debt finance. It could be project finance. It could be anything where you have a lot of documents that you're dealing with, whether it's due diligence, loan, consumer, not consumer, but commercial debt. All those have a plethora of documents, right? And they all have to be organized and moved through and tracked. Not just the drafting documents. These are the documents that underline the transaction. All those need to be managed and managed in one place where you're not using 3 or 4 or 5 different products. But the platform also allows connection to external resources as necessary to move the deal. So right now we're focused on M&A because it's our practice and that's what our rollout is. But the infrastructure, the architecture of the product can handle any kind of complex transaction. What it's not a firm product that you can use, in every area of every discipline, everywhere. It's not trying to be the be all and end all of legal tech. The idea is it's a vertical and you pick the vertical within the complex transaction management realm and you use it for those verticals independently.
So it's not a Swiss knife, it's more of a scalpel.
Yes, it's more of a scalpel, but in a particular discipline, it's not such a scalpel that it just does a document review and tracking. It looks at the transaction from inception. So, for example, an inception to completion. So, for example, it handles all the due diligence questions, either the drafting of them or the uploading of those questions, and then the answers to those questions, and then the extraction of data from those questions so that you can answer the representations and warranties, which is a critical component of all transaction. And then it moves into the closing checklists and the obligations to close, tracking all the closing obligations and also the post-closing obligations when you're rolling into integration of that entity. So all those modules are all built in because it mirrors what I was doing and what Conrad was doing on our deals. And we kept doing them over and over again. And I thought that was incredibly inefficient. So we built it from a senior artisanal lawyer's perspective. how can we make this easier for ourselves, and then the rest of our team, and then the client, and then the adversary. So it emanated from what I'll call our wisdom, our knowledge of the way we run deals, and how can we constantly monitor what's going on without changing the way we work. We just want to replicate our process, which happens in every deal, and do it in a manner that's easy to use without it being what other people call project management. No lawyer, no deal person wants to hear that they're being task managed. This just manages the flow of information, helps you get things done, and then moves it across.
I do appreciate that as two individuals who have been in that particular segment of the sector for many years. You have wide networks. Where do you see most of that early adoption currently happening? Is it equally on the side of the corporate and the law firms, or does one it stand out compared to the other?
Conrad, do you want to?
Well, we'll see, Timo, but the logical early adopters for this technology are the corporate departments at the Fortune 500s who are looking for efficiency, and they're already using the LSAPs. That this is just that on steroids. Another logical market, frankly, are the middle tier law firms. I mean, go below the AmLaw 200. Or a tool like Deal Driver in the hands of a middle market law firm, mitigates the labor advantage that the big firms have. It also mitigates the requirement for investing in hardware and technology because they can rely on a third party vetted platform. It effectively levels a playing field with them. Now, all that said, at the end of the day, and we can have that discussion separately, I do believe that at some point, some of the Fortune 200 the AmLaw 200 law firms are going to start experimenting with new models. And when they do that, when they start thinking about, how do we redeploy hours? How do we price ourselves more competitively and maintain the margins? Tools like Deal Driver in particular can help them do that and become more competitive. And I realize that's a big cultural lift, but it's going to happen.
Yeah. Timo, before you said it's hard when you're running your seminars. And by the way, next time you're running that seminar and you want people to talk about flat fee, give us a call. But it is hard. Those firms have an infrastructure built in that leverages personnel and so on. And they're great firms. We were at them. We know them. They're our friends. And it's hard for them to pivot quickly. And a tool like this doesn't necessarily have to make them offer flat fees, but can make them more efficient. But if they want to offer those flat fees, they have a lot more control over the process, and control over a process where you could monitor and watch what's going on with a window is a lot easier than to say, okay, well, that's where we spent, and now we might be able to have a better fee conversation with their clients.
It's also a matter of psychological adjustments, I believe. There has been many discussions in the industry stating that in the next 5 years, we're likely to probably even see a billable hour at 10,000 because of all the efficiencies that tools generate and the less time that is required from an expertise standpoint. So
That
You hear that in or I read that in some of the literature and so on, and I kind of laugh that, there'll be a billable hour. And the point is that it should be value or transaction pricing. It doesn't necessarily have to be hours, but everybody within the larger firms is so used to hours, and it's an easy metric to hold on to, but it's the wrong metric.
but it doesn't reflect the value. I mean, the 2 or 3 hours I spent marking up a letter of intent creates millions of dollars of value. I mean, we're just in a couple of earn-out disputes right now where that proves the case. And billing that time by the hour is ludicrous. Meanwhile, we overcharge for commodity work by inexperienced junior labor. And that client doesn't like that. I mean, the idea for BigLaw is to shift the value proposition from the commodity to the high value function that they deliver. And That's going to become obvious over time with the introduction of the large language models and the efficiency platforms. Um, Legal industry is vulnerable. I mean, the big law firms are vulnerable. They're the last industry that hasn't succumbed to innovation. But you're seeing the barbarians at the gate everywhere. KPMG is in the sandbox. The other accounting firms are jumping into the sandbox. We may jump into the sandbox. There's going to be, an opportunity, for different leveraged law firms that apply different processes, to hit every aspect of the law firm model. They're all those aspects are vulnerable. The way they compensate, the rainmakers to the overcharging of junior labor, all that can be rethought if you apply traditional business principles and leverage technology and process in the large language models. So there's going to be change, and some law firms will adopt.
So along those lines, let's just shift for a moment. The other product that we worked on with Codex, the Deal Mentor, is a tool that utilizes AI to create an interactive negotiation opportunity for young lawyers to be trained. And it's a big issue today, how you get that wisdom of senior artisanal, high-class lawyers down to each of the associates within their ranks, or even when they're in law school. And we worked long and hard with Stanford and Dr. Ma to develop that product. Initially, a free version that we posted on Hugging Face, but then now a commercial version, which is also rolling out this spring. Now it's spring into summer, and that tool utilizes AI, recognizing that senior lawyers don't have a lot of time. They can utilize this tool and infuse some of their wisdom into the tool and teach their way of negotiating very critical points in M&A transactions or in other types of transactions, or in dispensing knowledge from people that have wisdom down to others. But it's a multiplier. So it utilizes the AI conversationally. And it's an agentic system, meaning it has agents, multiple agents. In our current example, it's got an agent for the client. It has an agent for the adversary. It has a tax agent for each side. And the mentee, the student, or the young associate, is negotiating real time, and the mentor can watch and get a dialogue of what happened. And if the mentee wants to, they can peer into seeing what the adversary is saying to its client, to its tax counsel, and so on. And as they do that, the mentor will say, "Oh, well, you had to go look to understand what was going on behind the scenes. Next time, you have to do the model without doing that," and so on. And all that's there. It's a great leap of training, but it's because of our structure as a firm. We spent a significant amount of time that wasn't billable. And when I say significant, we're talking hundreds and hundreds of hours, actually thousands, if you really want to calculate for Conrad and I. And we spent that time in an effort to enhance our ability to train personnel. And also, we're happy to give it to others on a license basis, so that we can move the profession along and get people more efficient across the board.
I think that's quite inspirational because for me, some of the challenge in traditional law firms is that a lot of the partners in those organizations feel that historically, they have gone through the grind where they had to, spend countless of hours in training, countless of hours of mundane tasks. And that's essentially what made them good at their roles. And that's what has allowed them to be at a place where now, the billable hour is what it is, and now is their time to earn. And the next generation comes behind them, and they have to go through the same grind and the same training procedures. So it's almost like a notion that you need to suffer through a period of time so you can bear the fruits once you have gone through that process. And it's almost expected that juniors go through this. Where what I understand from you here is that this process can be a lot more sufficient. It can be a lot more
You mean But look, as one who lived through that process, and I'm still standing, so you can live through it. It's not an enjoyable experience to work as I did, the ridiculous number of hours and so on. But I don't want to say that those are not needed, because there is a tremendous value in the experience of everything. And matter of fact, the experience of failing or getting your butt kicked in an adversarial proceeding or a negotiation and otherwise, and with a good mentor by your side, there's nothing to replace that. But what this does do is it enhances the leverage of a partner or partners with their team, where the team can essentially repetitively hone their skill in the negotiation realm or in the learning realm in a very innovative way. And they'll still spend a lot of time working on deals, probably until late night, but we can accelerate their abilities much, much faster. And so therefore, maybe they won't have to spend as much time failing, and they can up their skills sooner. And so therefore, that track won't be as grueling, as I used the word. It'll be more humane. I don't think you'll take away completely the hours that are necessary to have the gut feel of what's right or to learn. You can't get it out of a book. Interactive work works, but long hours will still continue. But I don't think they need to be at the same levels that maybe Conrad and I and many of the senior partners at firms everywhere had experienced themselves. I think there's a better way of doing a lot of this.
Or perhaps at the very least, they can be a little bit more enjoyable.
Yes. Yes, it is gamified, which is, and that happened as a result of feedback from users. It's a constant refrain in the gaming industry. If it's too easy, no one wants to play with it. And so there are pitfalls in the platform that can be increased higher levels, harder, so on and so forth. And it is gamified intentionally because gamification in learning actually drives better outcomes of that knowledge.
And going back to your core tool, I'm quite interested in hearing from you briefly how does the product differs to some of the more established players on the market, the likes of Litera Transact, the likes of HiQ, and even some of the contenders on the market, such as Deal Closer that came out of Canada a few years back.
Yeah, so ours is generally more comprehensive. So it starts with people uploading their diligence requests. It presents the diligence requests and parses those information into various areas, categories, subcategories, topics, so that way they can be filtered and controlled. One thing that's unique about the platform is it's showing the questions and the narrative answers. Due diligence requests now have become like interrogatories in litigation, where there are questions not just leading to documents, but questions that they want answered. And so everything is all in one place where you see question, all the categorization, so you can filter it and so on. And then the answers, the narrative answers, and the documents. The documents can be looked at in place. They can be annotated by the buy sides, not seen by the sell side, annotated. You can use AI to extract the clauses if you want to that are necessary for your deal, your transaction, your issues. And some of the unique features are that it controls who sees what, where, and when. So, for example, you're a young associate, you're a young man, so you're a young associate somewhere, and you're allowed to see one topic, one area, and so on. With a click of a button, you'll be assigned to work on this one area. I, as the partner running the deal, see all areas everywhere. You can draft something, and I can see that you're drafting an answer. Let's say you're on the sell side. It's only seen by the sell side, and then when I look at it, I can publish it, and now it goes to the buy side. There's a lot of controls that allow for collaboration on one platform, but across the two different teams, things will be maintained private and then released later for sharing and collaboration. So it starts with the very earliest of diligence, goes through the collection of the documents, it goes through the analysis of the documents, it goes through the generation of the schedules that are responsive to the representations and warranties. It goes through closing checklists, allows you to build the closing checklist based upon the actual components in the deal. and then in turn allows you to execute on that closing checklist and then utilize that data for post-closing integration. And then if you're doing multiple deals that many corporations do, you can roll up the data and look across all of your portfolio and roll up the data to see, for example, you have leases of buildings scattered across one city, and that's inefficient. You should consolidate them into one place. So our competitors are, to use the term we used earlier, are more dagger-like or scalpel-like with regard to a particular component. We looked at it as, can we keep you in one transaction from beginning to end so that you don't have to jump in and out, exporting data, importing data, exporting data, importing data into the various tools. Those tools are all very good. And if someone wants to maintain some of those tools, we can build the API to that. But realistically, we wound up building most of them in this particular domain of complex transactions so that it is a comprehensive solution from that perspective.
It's a full life cycle management. So we're introducing the process. As Lenny says, these other tools do something. They extract intelligence out of a document, they summarize a document, they store a document, but we're introducing the process that ties them all together. And we do it, unlike them, not in a cul-de-sac. We do it in an open architecture environment where you can bring in your APIs. If you have storage solutions you like, if you have a large language model you like to use, you can tie it all in. It's all open. And that nobody else has tied all the pieces together. And we did it again. We did it as a utility for ourselves so that we could price ourselves on a fixed fee basis. But it became, it became interesting as in and of itself to the commercial world. And that's where, we're very different than them.
Gentlemen, that's all very exciting. I would like to thank you again for taking the time to speak with me today. Thank you very much for being a continuous supporter and sponsor to Legal Innovators California. We look forward to having you, and we look forward to seeing the latest innovation that has come out from the Flatiron Law Group. This time, 2 more tools than before. Thank you.
Look, Timo, thank you very much. I will tell you that this is the one legal tech arena that we will always go to. It is unmatched, and I'm not just blowing smoke here. It's unmatched. We've been doing it since you started it, and it continues to grow. It provides the best audience for our purposes. It provides an intelligent audience that really knows where innovation is and they're looking for the next edge. It's always managed extremely well, and we appreciate your ability to manage it and run it. So
Because it's not just the billboard for the vendors. You're actually chasing real innovation, and real innovation comes from a lot of places and a lot of small places.